Imagine the scenario. Your car, it's fully paid off, yours free and clear, and suddenly it gets seized by the government.
Okay.
Not because you owe any taxes, but because, say, a business you leased it to, maybe even just a friend who borrowed it, racked up some huge, totally unrelated customs debt.
Wow. Yeah, that sounds pretty extreme, almost unbelievable.
It sounds far-fetched. But for a time in South Africa, this wasn't just some hypothetical worry. It was a real possibility, especially for businesses involved in leasing or financing goods.
It really highlights a tension, doesn't it, between the state needing to collect revenue and, well, your basic property rights.
Welcome to the deep dive. We unpack complex topics, pull out the key insights, and give you that shortcut to being well-informed.
And today, we're diving into a really significant South African legal case. First, National Bank of SA Limited v. the Commissioner for the South African Revenue Services and the Minister of Finance, often just called the FNB case.
Yeah, and this isn't just dry legal stuff. It's actually a fascinating look at property rights, where the limits of state power lie, and what arbitrary really means when the government can potentially take your stuff.
Exactly. We'll walk through the core issues, the arguments from both sides, how the court reasoned its way through it, and the impact it had. Hopefully, you'll see why this case matters, way beyond just lawyers and courtrooms.
Okay, so let's set the stage. Who are the main players here?
Well, first up, you have the appellant, the one challenging the law, First National Bank, or FNB, a major bank, obviously, and part of their business involves leasing and selling things like cars.
Right, standard financial institution stuff.
Then you have the Commissioner for SARS, the head of the South African Revenue Service, the tax authority.
The tax man, essentially.
Pretty much. And also the Minister of Finance, the government minister responsible for the laws, SARS administers. So it's FNB versus the state's tax collection machinery.
And the whole fight centered around one specific piece of law, right?
Yes, Section 114 of the Customs and Excise Act. Now, this act is mostly about collecting customs duties, taxes on imported goods.
But Section 114 had a couple of, let's say, very powerful features that caused the problem.
And that's putting it mildly. Let's break down those two key features. First, it allowed the Commissioner SARS to basically seize and sell goods to cover a customs debt without needing to go to court first.
No prior judgment needed, just seize and sell.
Correct. They could just decide the debt was owed and take action.
Okay, that's already quite a bit of power. What was the second feature?
And this was the real kicker for FNB. Section 114 allowed the commissioner to seize and sell goods, even if those goods didn't belong to the person who actually owed the customs debt.
Wait, so if someone owed customs duties, SARS could seize property belonging to a completely different person just because the debtor had it?
Precisely. If your goods were merely in the possession or under the control of the customs debtor, your property could be used to pay their tax bill.
Okay, now I see where FNB comes in. How did this play out for them specifically?
Right. So FNB had leased a VW Jetta to a company called Lorray Manufacturers. They'd also leased a VW Garf to another company, Airpark Cold Halal Storage.
And there was a third vehicle, too.
Yes. They'd also sold a Mercedes-Benz to Airpark, but under an installment sale agreement. Critically, this meant FNB retained legal ownership of the Mercedes until the very last payment was made.
So FNB legally owned all three cars at the time.
Correct. Now, Lorray and Airpark ran into trouble with customs. Lorray allegedly owed about R$3.26 million related to fabric smuggling.
Okay.
And Airpark owed over R$640,000 apparently for taking goods out of a customs warehouse without paying the duties.
Big debts. So SARS looks at these debts.
And under the power of Section 114, the commissioner detained those three vehicles, the Jetta, the Golf, the Mercedes, all owned by FNB.
Even though FNB had nothing to do with the alleged smuggling or unpaid duties.
Exactly. FNB wasn't the customs debtor here. Their property was just, well, in the wrong place at the wrong time, according to SAR's interpretation of Section 114.
So FNB obviously wasn't happy about this. What do they argue?
They took it to court, arguing that Section 114 violated their constitutional rights. Specifically, they pointed to Section 25, the right to property.
Makes sense.
Also Section 34, the right of access to courts because SARS could act without prior judgment. And Section 22, the right to freedom of trade, arguing it hampered their leasing business.
Okay, so they had a multi-pronged constitutional attack. How did the High Court handle it initially?
Well, this first round actually went to SARS. The High Court dismissed FNB's challenge and said Section 114 was constitutionally sound.
Really? How did they justify that, especially the part about seizing property from someone who didn't owe the debt?
Their reasoning was interesting and ultimately controversial. They compare the power in Section 114 to things like a common law link, where a mechanic might hold onto your car until you pay the repair bill.
Okay.
Or a landlord's hypothec, the right a landlord has over goods on the premises for unpaid rent. They argued that just detaining the goods wasn't really a deprivation of property yet. The constitutional issue only kicked in if the goods were actually sold.
That seems like a fine line. What about the third-party ownership issue?
This is where it got really problematic. The High Court came up with this idea that owners like F&B, whose goods happened to be with the customs debtor, somehow became co-principal tax debtors.
Co-principal debtors, just because their car was leased to someone who owed tax.
Effectively, yes. And they added that rather famous or infamous line, "There is no equity about a tax," basically saying fairness doesn't really factor into tax collection.
Wow, that's a blunt instrument approach.
It is. They also said it wasn't expropriation in the usual sense, which typically requires compensation, and they felt there weren't less invasive ways for SARS to do its job, pointing out some other countries had similar laws.
Did they acknowledge that taking F&B's cars wouldn't actually raise much money compared to the massive debts?
They did. The High Court noted the money raised from selling third-party goods was likely next to nothing, but they argued the coercive effect, basically pressuring the actual debtor or maybe their associates, was considerable.
So the High Court essentially said, tough luck, F&B. Tax collection trumps your property rights in this case, even if you're an innocent third party. But F&B appealed, right?
Absolutely. They took it straight to the Constitutional Court, the highest court for these matters, and this is where the case really gets interesting and sets major precedents.
So the Constitutional Court steps in. What's their first move?
First, they confirmed the 1996 Constitution applied. Even though the cars were detained before it fully kicked in, the threat of selling them continued under the new constitutional regime.
And then they tackled a really fundamental question, didn't they, about who even gets property rights under the Constitution?
Yes, this was crucial. The court made it absolutely clear that juristic persons, that means companies, like F&B, are entitled to the property rights protected by Section 25.
So it's not just individuals. Businesses get property protection, too.
Definitely. The court said denying this would be disastrous for the business world and would damage the very fabric of democracy in South Africa. So that was a huge clarification. Your business's assets are constitutionally protected.
Okay, good to know. Then how did they define property itself? Was F&B's ownership of these cars definitely property?
Unequivocally, the court stated that owning a physical, movable thing, corporeal movable, in legal terms like these vehicles, is right at the heart of what Section 25 protects.
Did it matter that F&B's interest was mainly financial, getting the lease payments or the final sale price, rather than, say, driving the cars themselves?
Not at all. The court said the legal right of ownership itself is what's protected, regardless of whether the interest is commercial or personal. That's a key point for understanding property law.
Right. Now, the Constitution talks about deprivation and expropriation of property. How did the court distinguish those?
They clarify that deprivation is the broader category. It covers any interference with the use, enjoyment, or disposal of your property.
So any limitation is a deprivation.
Essentially, yes. Expropriation is a specific, more severe type of deprivation where the state actually takes ownership, usually for a public purpose, and crucially must pay compensation.
Got it. So expropriation needs compensation, deprivation doesn't necessarily, but it still has to be constitutional.
Exactly. The court said the first question you always ask in a Section 25 case is, has there been a deprivation? If yes, then you move to the next question.
Which is
whether that deprivation is arbitrary. Section 25(1) says, no one may be deprived of property except in terms of law of general application, and no law may permit arbitrary deprivation of property.
Okay, arbitrary. That sounds like the core issue here. How did the court define what makes a deprivation arbitrary? Was it just about being irrational?
No, they specifically rejected that narrow view. It's not just about whether the law has some rational connection to its purpose. The court said arbitrary here means something broader. The law must provide sufficient reason for the deprivation.
Sufficient reason. Okay, that sounds subjective. How do you determine if the reason is sufficient?
It involves a complex balancing exercise. You have to look at the relationship between the means used, the deprivation, and the ends sought, the purpose of the law.
What factors go into that balance?
Several key things. First, the connection or lack thereof between the purpose of the deprivation and the specific person whose property is being taken.
Like F&B, who had no connection to the customs debt.
Precisely. Second, the connection between the purpose and the nature of the property. Depriving someone of their home, for instance, might need a much stronger reason than depriving them of, say, contraband.
Makes sense. Land versus a car versus illegal goods.
Third, the extent of the deprivation. Is it a temporary limitation, or are you losing the property entirely, like F&B potentially faced with the sale of its cars? A total loss needs a much more compelling justification.
And didn't they also say context matters? South Africa's specific history?
Yes, absolutely. The court emphasized that you have to consider South Africa's past, the constitutional goal of social justice, and the overall spirit of the Bill of Rights. It's not just a technical legal test. It's grounded in the country's values.
Okay, so armed with this definition of arbitrary as needing sufficient reason based on that balancing act, how did the court apply it to Section 114?
Well, first, they completely dismantled the High Court's co-principal debtor idea.
Yeah, that seemed shaky from the start.
The Constitutional Court agreed. They said, look, FNB was not a customs debtor. They owed SARS nothing. Their property was being seized purely for someone else's debt. That was the fundamental issue.
So why did Section 114 fail the sufficient reason test? Why was it arbitrary when applied to third parties like FNB?
The court found it was far too wide. It allowed for the total deprivation of FNB's property, the seizure and potential sale of the cars, under circumstances where, crucially, one, FNB, the owner, had no connection whatsoever with the transaction that created the customs debt.
Right, they weren't involved in the smuggling or the warehouse issue.
Two, the property itself, the vehicles, had no connection to the customs debt. They weren't proceeds of crime or used to commit the offense.
Unlike, say, a boat used for smuggling fish.
Exactly. And three, FNB hadn't done anything to mislead SARS or contribute to the situation. They hadn't, for example, created a false impression that the debtor actually owned the cars.
So this complete lack of connection, this absence of a nexus, was the fatal flaw.
That was the core of it. The court looked at laws in other countries, like the U.S. or Australia, where third-party property could sometimes be seized, but they found those cases always involved some link, some nexus, between the owner of the property and the underlying illegal activity or debt.
Like the fishing boat example again. The owner might not have been fishing illegally, but it was their boat being used.
Correct. Or maybe an aircraft owner benefits from unpaid airport fees secured by a lien on the plane. There was usually some connection. But here, with FNB in these cars, the connection was non-existent. FNB was truly an innocent bystander whose property got caught up purely because of its location.
So, because there was no sufficient reason, no real nexus, the deprivation authorized by Section 114 against third parties like FNB was deemed arbitrary.
Yes, and therefore it infringed Section 25 of the Constitution.
But that's not the end of the story, is it? Even if a right is infringed, the government can sometimes justify the limitation.
That's right. The final step is the justification analysis under Section 36 of the Constitution. Can the limitation be justified as reasonable and justifiable in an open and democratic society?
How did Section 114 fare there?
It failed spectacularly. The court found the infringement of FNB's property rights was grossly disproportional to the purpose Section 114 was trying to achieve by seizing third-party goods.
Because, as the High Court even admitted, the money raised was next to nothing.
Exactly. The Constitutional Court hammered this point home. You can't justify such a severe infringement of a fundamental right like property for such a negligible financial gain to the state.
What about the coercive effect argument the High Court liked? That maybe seizing FNB's cars would pressure Lorre and Airpark to pay up.
The Constitutional Court dismissed that too. They basically said you can't justify infringing someone's constitutional rights as a way to coerce someone else, especially when the benefit to the state is so tiny. State coercion based on rights violations is not a legitimate justification.
So the infringement wasn't reasonable or justifiable? The final verdict.
Section 114 was declared constitutionally invalid. Game over for that part of the law.
A clear win for FNB and property rights. But was the whole Section 114 struck down?
No, and this is important. The court tailored its order carefully. It declared Section 114 invalid only to the extent that it allowed SARS to detain and sell goods belonging to people who were not the actual customs debtor.
So SARS could still use Section 114 against the actual debtors themselves, just not against innocent third parties like FNB.
Precisely. It targeted this specific constitutional defect.
Were there any other limitations on the order? Like, what about past cases?
Yes, to avoid chaos, the court made the order not retrospective in certain situations. It didn't invalidate sales that had already happened where the buyer had taken possession.
Okay, practical.
And it didn't apply to cases that were already completely finalized by a court judgment with no appeal pending.
Did they suspend the order, give Parliament time to fix the law before it took effect?
Interestingly, no. They chose not to suspend the declaration of invalidity.
Why not? Usually they give Parliament a chance.
Their reasoning was that the invalid part affected only a minute proportion of goods seized by SARS, and the financial impact on the state was negligible. Suspending the order would mean forcing more innocent owners like F&B to continue suffering an unconstitutional deprivation of their property, which the court felt was disproportionate.
So the message to Parliament was clear. Fix this and fix it now, but in the meantime, you can't keep seizing third-party property this way.
Exactly. The ball was firmly in Parliament's court to draft a new, narrower law that respected the constitutional boundaries, perhaps allowing seizure only where that crucial nexus exists.
What about F&B's other arguments, access to courts, freedom of trade? Did the court rule on those?
They didn't need to, because F&B got the relief it wanted based on the property rights argument alone. However, the court did mention it had substantial doubts about whether Section 114 was consistent with the right of access to courts either, hinting that the lack of prior judicial oversight was also constitutionally problematic.
Okay, so let's wrap this up. What's the big takeaway here for you, the listener?
Well, this deep dive really shows how robustly the South African Constitution protects property rights. Even for big corporations like F&B, those rights are fundamental.
And it gives real teeth to the word arbitrary, doesn't it? It's not just about rationality, it's about sufficient reason.
Exactly. It demands a proper justification, a balancing act, a real connection between the state's goal and the impact on the individual or entity whose property is affected. It puts a significant check on state power.
Ensuring that even when the state is doing something vital, like collecting taxes, it can't just override fundamental rights without a very compelling, proportional reason and that all-important nexus.
Right. It shows that the state's power to tax, while essential, isn't absolute. It has to be wielded fairly and constitutionally, especially when it impacts people who haven't done anything wrong.
So it leaves us with a really interesting question to think about. How do we strike that balance? The state absolutely needs to collect revenue, that's undeniable. But how do we balance that need with the fundamental right to own property, particularly when the property and its owner are completely disconnected from the debt?
It's a constant tension in law and policy, isn't it? Finding that line between efficient administration and individual rights. This case drew a very important line in the sand for South Africa, reminding us that proportionality and fairness matter even when dealing with the taxman.